Hello and welcome to Legally Speaking with me, Tarun Nangia. We are today going to discuss an issue that will touch about all the entire population of India, which is close to 150 crores, that will be affected by the Electricity Amendment Bill 2026. This sector is also very interesting because this is the most litigious sector. There is so much of litigation in this sector. There's so much of, and pan India. I mean, every state will have hundreds and thousands of litigations, and there is just so much happening in the power sector. And that's why this bill, of course, will have a far reaching impact, principally being the whole talk of having multiple players who can provide the electricity services to commercial and domestic users in a single geographical area. As of now, we had carved out areas for different companies where there was only principally one seller of power which we could buy from. This is a sea change. Indians have never seen this before. Even I don't understand how this is supposed to play out, given that the infrastructure is common. But I think that's for the experts to answer. I want to welcome Senior Advocate Buddy Ranganathan. Thank you for your time and thank you for joining us on Legally Speaking, and Advocate Sri Venkatesh, and most of all, whose comments we would await on this whole issue is Justice R.S. Chauhan, who we all know has served as the Chief Justice of Uttarakhand, and he sort of has a keen bird's eye view and has studied this subject. And we request you to share your overview on the show. At the outset, let me request Senior Advocate Buddy Ranganathan to give the opening comment, and then we move on. Over to you.
Thank you, Tarun. Thank you for inviting me on the show. And it's very nice to share the same screen with illustrious people like Justice Chauhan and my friend Sri Venkatesh, whom, of course, I affectionately call Venki. He allows me that privilege. But it's very nice to be here. The electricity sector is surely one of the sectors which currently ongoing a lot of changes, a lot of turmoil, a lot of new developments. And that is something that, fortunately for us, keeps people like Venki and me in demand. So, we remain grateful for these changes and for these things which are taking place in the electricity sector. So, Tarun, in terms of the new national electricity policy which is being promulgated, there are several good points, frankly. There are several points which have been brought into focus, which are surely there to stay for the next good 10, 15 years. But like most other policy documents, I think it could have done a little more. It could have also focused on certain aspects of the electricity sector, which I think need urgent attention. And there are certain aspects which I simply cannot agree with, which we will deal with in a little more detail. So maybe I can hand over to Justice Chauhan and we can hear from him first. And then Venki and I can take a go at it.
Point well taken. I'll go to Advocate Sri Venkatesh, who will give a curtain raiser on the Electricity Amendment Bill and raise some head points on what he finds the bill is taking forward in the sector, and what issues need a relook. Some issues do they need some more discussion. All of that and more in his comment. Over to you.
Thank you, Tarun. So, as Buddy just indicated, that this electricity sector, while has had its good run for the last 23 years in terms of, a lot of privatization, a lot of investment coming into the picture, a lot of disputes, a lot of problems also that we have seen encountered over the years. But there is actually now a requirement to shift the focus from electrification to something other than that. When the 2003 Act came, the idea was really electrification. That seemed to be the primary objective, because ultimately that was something where we were lagging behind. That was a focal point in 2003. Now in 2026, we have two documents to discuss. One, of course, is the bill, which is right now not been tabled before the parliament. Therefore, I don't know to what extent would we want to get into it. What is actually also available in the public domain is the policy document. Because policy is nothing but a sort of a vision of the central government which they issue every decennial, every 10 years. They issued in 2006, they issued in 2010, and then now issued in 2026. In those policy documents, the government really wants to bring out its vision for the power market or the power sector to progress towards. So I think that is what is interesting that we need to look at. So I agree with Buddy that there are certain issues which are very interesting, certain issues which are very alarming, which may have a far-reaching consequence on the larger consumer interest, so to speak. So there are about five things that I could come across which are found to be a little radical, which is very different from what 2016 policy contemplated, and which, in my understanding, would be a challenge if the act is not amended. Because simply having a policy which does not have the backing of the parent statute would be a difficult document to implement. So these are the five things that I could think about. First and foremost, there is now a concept of automatic index tariff revision. See, Delhi is a battle where Mr. Ranganathan has been a bulwark in fighting against the Delhi regulator. They don't revise the tariff. So now the policy says automatically it will revise. So this is something very interesting, very welcoming. But what is the enabling framework under the parent statute still required to be seen? Second is there is no universal service obligation for a consumer of 1 megawatt and above. Now, what that effectively means is that all the high-end consumers in a distribution licensees mix. They are up for grabs from anybody and everybody. So it's an open play, open competition. While very good for industry per se, because industry will have the choice to choose between X licensee and Y licensee and optimize its cost of procurement. But having said that, the distribution licensee will lose out on a lot of revenue. So that is something which needs to be balanced. Thirdly, of course, they want to abolish cross subsidy surcharge on manufacturing activities, which was never the case because the act only exempted it from captive consumption, not on any activity, which is also a radical idea. And lastly, I think the government realizes that with all this renewable energy which is being produced in the country, and we've met all the targets. In fact, we've surpassed all our goals, international convention goals, etc., etc. There is a need to have a balancing network of battery storage operators in the country because this RE power is not effectively being utilized across throughout the day in the country. So therefore, there's a huge let's say emphasis on storage capacity. So these are the four or five broad indicators that I could see through the policy, which I find to be radically different than what the current scheme is. Of course, they have their own challenges that they will have to perhaps amend the parent statute. Then only this policy could perhaps be implemented. But that is again not tabled before the parliament yet. So that is for time to see. Therefore, this is my opening understanding of the two documents which are before us today in terms of
The
debate and
draft.
discussion.
Okay. Thank you, Advocate Sri Venkatesh, for sharing your opinion on the draft. I'd go to Justice R.S. Chauhan for his opening comment.
Firstly, thank you for inviting me to your show, Tarun. Basically, I agree with what Mr. Venkatesh and Mr. Ranganathan have said. If you really look at the policy 2026, it's almost like an outline sketch given by an artist. Now, he will tell you that this is what overall the picture will be. However, the nitty-gritty details of that painting are yet to be pushed in. Number one. Number two, yes, what is interesting about this policy is that it is looking at two aspects. Number one, the practical problems that are faced by the electricity sector today, and yet at the same time, it looks at the future. And to me, that is a very good policy perspective. Yes, there are certain details that we are still waiting for to see how it will be resolved. But as Mr. Venkatesh rightly put it, it all depends on how you amend your act. For example, when you talk about automatic tariff revision, now that is a good thing to have because as Mr. Ranganathan has been fighting the battle to get the tariffs revised. But the other question is that there's a cap in the act which says that thou shalt not revise it to the extent that it starts hurting the consumer. Now, how do you work both these things out together will be very interesting to see because they are practically opposed to each other. Suppose if the yearly tariff gets revised to the extent that it starts hurting the interest of the consumer, then who will step in? Is it that the commission will step in and say, I'm sorry, you are not permitted to revise to this extent? How will it work out? But anyway, all those nitty-gritty details naturally will have to be worked out before this policy is actually put into action. But I think the vision of the policy is very interesting, and as pointed out by both Mr. Ranganathan and Mr. Venkatesh, uh, there are a lot of dynamic thinking that's going on, and that is very heartening to know, especially with regard to the variable renewable energy sector. Let us see where India leads, because now we are entering into the green hydrogen sector. Perhaps we will become one of the leaders of the world. So I think the prospects are very bright, but let us see how it translates itself.
You know what I want to highlight, which I will read out to you, and I would request the opinion of all three of you, is what our MOS for Power, Mr. Shripad Yeso Nayak, said in Parliament. He said that the draft amendment bill, electricity amendment bill, is aimed at cutting infrastructure duplication in the power sector, and this it's doing by allowing multiple licensees in the same area to share the infrastructure, and the costs that for using that network will be decided by the regulatory commission. He also said that this will sort of save a huge cost. Otherwise, every licensee will have to build its own network, resulting in duplication of poles, wires, substation. That only makes power costlier. And he said this in Rajya Sabha a few days ago, this 2 days ago. And now he also went and highlighted uh, that there will be regulatory oversight to this whole process, because this is the first time that we are going to sort of undertake such an initiative where for every area there could be multiple sellers of power, and a clear framework will be sort of brought out so that this could be done smoothly. Uh, I actually don't understand how is this going to be possible, because this, on the face of it, looks very confusing. Maybe the experts know it better, but let's take the opinion of someone who litigate a lot in this sector. I'll go to Senior Advocate Buddy Ranganathan for his comment.
Thank you, Tarun. Yes, you're absolutely right. This is a very interesting concept, but it is not being introduced for the first time in this new amendment bill. The possibility of having multiple licensees already exists in the Electricity Act 2003. We already have situations of multiple licensees in the same area in 2 or 3 parts of the country, the primary being Bombay, where the northern part of Bombay is covered by Adani and Tata, and the southern part of Bombay is covered by Tata and BEST. So we already have areas where you have multiple licenses in the country. You have Torrent in Ahmedabad, for example, where you have the state discom and you have Torrent. You also have places in Bengal, which is called the Asansol Raniganj district, where you have 3 licenses. So you have the West Bengal State Distribution Company, you have DVC, which is very close to Venki's heart, and you also have another third licensee called called India Power Company Limited. So you actually have 3 licensees in the same area giving supply to consumers. So what is being proposed is actually not very new. It already exists even in the 2003 Act. There are, of course, some differences. In the case of the Raniganj Asansol district, all the 3 licensees have to use their own networks. There is no network sharing. The network sharing actually started, or even continuing even till date, in Bombay. And all this actually started many years back. But the sharing of the network emanated from a judgment of the Appellate Tribunal for Electricity in Appeal 246 of 2012 of the case of Tata Power versus the MERC, where the tribunal said that the commission must explore the possibility of sharing the network for 2 reasons. One is the saving of cost, because as you very rightly said, that if 2 licensees create their own independent networks, obviously the cost is going to be double. But the second part, of course, also was about the sharing of the network. Now, this sharing of the network has been attempted by the MERC, the Maharashtra Electricity Regulatory Commission, in a series of orders starting from 2012 onwards. But the sheer number of disputes and the sheer number of differences which have happened between the two licensees in Bombay is humongous. Those disputes are still being fought in the courts today at various levels, some in the MERC, some in the APTEL, some in the Supreme Court, and those disputes are still going on. There is virtually, literally a dispute on every single new line which is sought to be laid, every single new substation which is sought to be set up. So maybe it's good for consumers, maybe it's not. That I think time will still tell. But it's surely good for the legal profession. I mean, I can tell you that because of the sheer number of disputes which have happened on that small area. But having said that, even today in the draft Electricity Amendment Act and in this new National Electricity Policy which is there is no clear framework as to how this will be effectuated. We have learned from the Bombay experience. We have learned that the disputes and that the areas of controversy are huge. But there is no clear framework as to how it will be done. That's one. The second is, what happens to existing networks of existing licensees? So today, for example, you may have the Delhi Discoms, you may have the UP Discoms, you may have Gujarat, you may have Tamil Nadu, you may have wherever. Now, all these distribution companies have set up their networks over the past 50, 60, 70, 80 years. There are costs which have been incurred on the setting up of that network, and there are costs which are being incurred on the continued upkeep and running of those networks. Now, who pays that cost? So if a new licensee walks into the same area and now says, Mr. Existing licensee, please give me over your network because I need to now come and sell to consumers in that area. What happens to the cost of the network which is already laid? What happens, more importantly, to the cost of the network which is laid but not yet recovered in tariff, which all of us call regulatory asset? And India's got a surfeit of regulatory asset. Today we are talking about 1 lakh crores and 1,70,000 crores and numbers which are mind-boggling. So what happens to that unrecovered cost which is supposed to be spent on that network? Now, who's going to recover that cost? So just to give you an example. So in Delhi, for example, you have, say, BSES Rajdhani in the south of Delhi. It lays its network. It has a pending claim today of several thousand crores of regulatory asset, which it has spent on its network and not recovered. Tomorrow, a new licensee walks in, tells BSES Rajdhani, boss, I'm taking your network, I'm going to sell to the consumers in that particular area, maybe Friends Colony, maybe Maharani Bagh, maybe Niti Bagh, wherever it is. Now, the new licensee comes and sells in this area. What happens to the unrecovered cost of the network in these areas? Will the new licensee collect it? Will the new licensee collect it and make it over to BRPL? Will BRPL continue to recover its unrecovered cost in addition to what the new licensee is going to incur? These are all very, very complicated issues. There are no easy solutions to this. And unfortunately, neither the Electricity Amendment Act nor even the policy come anywhere close to laying down a framework for how this is going to be done. So in theory, it's a brilliant principle. Absolutely no doubt about it. But it has been done in things like, say, transmission. So where you have the central transmission utility laying down the power grid network for the whole of the country and everybody then uses it. It's a common transmission network which everybody can use. Now, if you're going to conceive a distribution network in the same frame as a transmission network, there are a host of issues. So in theory, it sounds very nice. It is very nice. But the practical working of it is going to be very, very difficult.
Point well taken and shared about the sunk investment cost in the infrastructure created by the DISCOM. I'll go to Advocate Sri Venkatesh for his analysis of this predicament.
So, Tarun, I'll tell you, I had the occasion of being part of this. I'm sure Mr. Ranganathan was also part of this dispute, this Bombay dispute between Tata and Adani. See, our act, when it came in 2003, it actually contemplated parallel licensees, but it contemplated supply of power through your own network. That is the original act as it stands on the
Yes,
statute
yes,
book. Now, the tribunal was faced with a situation saying that, look, there are two licensees, Tata's and Adani. Tata's wish to lay the network. Adani's or that time Reliance were against that laying of network because they said, look, they are laying networks only in high density areas and not in low density areas. So they're cherry picking consumer. That was the allegation. So the question that which came up for consideration was that, look, uh, why should a duplication network be permitted? Why can't one use the other? Now, this was actually in teeth of what the act actually said. The tribunal said no, try and explore the opportunity of using each other's network. Now that was the genesis and how till date in Bombay there's something called as changeover and switchover consumers. Changeover means a Tata consumer buying power over Adani's line. A switchover consumer means a Tata consumer switching physically to Adani line. So that's really how they operate in Bombay. So to Mr. Ranganathan's point, while I agree that the enabling framework is not yet on paper, it's not discernible from the paper, but in my own experience, how MERC maturely handled, it derived a fixed cost of the existing assets of Adani for the purposes of supplying power through changeover. It said, look, Tata, if you wish to use the network of Adani and supply power from your network, supply power yourself, then you will have to recover this additional cost and give it back to the licensee who owned the wires. That was of course, that is to begin with, that was a very simplistic formula to make sure that the incumbent licensee who set up the network gets paid. The licensee who's using the wires, the supply licensee also recovers that cost and pays that money to them and makes his profit in terms of selling power. So it started with that. That was the basis and how Bombay started. Of course, now after that there has been a lot of disputes as to, because there is still some gray area saying that who will lay new network, because there are some protocols set up by MERC, the regulator there, that who will lay network in terms of. Bombay has a very unique problem. Bombay does not does not. It grows vertically. So you may have an existing network, one substation very close to a big building coming up. So the fight is who will supply in the building. So let's park that aside for a minute. I personally foresee, as long as regulators are willing to emulate what MERC did on first principle basis, which is to decide what is the required recovery of cost of the existing network, this wire and supply licensing business can work itself out, because then you will not be competing to lay network. You will actually be competing only on cost optimization and supply of power, because a large part of your supply of your as a distribution licensee is not just the cost of network, the cost of power procurement. So the real fight will be who will be more cost optimal in terms of giving the final price to the consumer. Of course, here I still feel that the legacy licensees will have a tough time, because they have signed contracts for 25 years in 2010 and 11, whereas the newer licensee will not sign 25-year contracts. So they will have to emulate some kind of pooling of power purchase, etc., so that this is socialized. But ultimately, with these two, three safeguards, if done correctly, according to me, this parallel licensing can actually do wonders in many parts of our country where there is an urban requirement of power, more so when it comes to HT and EHT consumers. They require large quantum of power and they are actually landlocked to an incumbent licensee, and they're finding it difficult there. So this is really going to be, the advantages may not flow to end consumers like us immediately, but it will definitely flow to the economy as a large. So I think that is where there is an opportunity, according to me, that of course this framework will have to be created. Bombay did it, MERC did it, it stood the test of time, and therefore things are still operating very proficiently there. Similar forward thinking is required from all the regulators across the country to sort of implement this scheme, because right now the plain text of the law is not very clear on how this scheme is to be implemented. That's where I see a lot of opportunity. Of course, regulators will have to be a little forward thinking in that aspect.
Indeed, and as far as you said about long-term PPAs already in place, there's not much that can really be done in changing the cost of procurement once you have signed a long-term PPA.
Yes.
So,
So for example, there was a proposal for at least central government generating stations that all the long-term contracts should be pooled to one particular entity, and then he should supply power on an average basis to everybody else, as opposed to a fully depreciated plant supplying power only to, let's say, Tamil Nadu, and a high expensive power plant supplying power to a state like Delhi. They said, let's socialize it. Of course, these are all regulatory interventions that the government is trying to look at, and even the regulators are trying to look at. But this will have to be done at some level. Otherwise, you will have a new licensee supplying power at 1/3 or 1/4 the cost of an existing licensee. Then there is no fun of competition. So competition should be within the limited means and safeguards. So I think should be the idea of doing.
Point well taken, Advocate Sri Venkatesh. I'll take this to Justice Chauhan and also want to ask him, sir. Many people have signed PPAs at rates of 6 rupees and 6.5 rupees also, and they are still continuing. They will continue for a few more years. You can't really wish them away. And then when you have new, discoms, suppliers allowed, the existing one has a PPA at 6 rupees or 6.5 rupees. The new guy will come and offer it at 3.5 rupees. Using the sunk infrastructure cost of the existing guy, the new guy can take over his whole market. Do you think that this is a badly planned policy? To this limited extent, more thought is needed.
I don't think it's a badly planned policy, no. The mere fact that there's a possibility of too many chefs coming into the kitchen and spoiling the stew does not mean that we cannot regulate the coming of the chefs into the kitchen. Rightly pointed out by Mr. Ranganathan that yes, you will have conflict of interest. May have too many, people saying that, look, who pays if I use your facilities for transmission or for distribution? But at the same time, what Mr. Venkatesh is suggesting that we already have experience. It's not that we are beginning a new game. We already have some experience. We know what the rules can be set up. And as I said, this is merely an outline. We have to wait till everything nitty-gritty details are filled in, and hopefully, A, they will be filled in by those who are experts in the field. B, yes, I hope when we are talking about amending the act, I hope they will discuss this with the electricity producers, the distributors, the generators, and with legal luminaries like Mr. Ranganathan and Mr. Venkatesh, that how do we go about it? Because these are the two gentlemen who see it from the inside the boxing match. They're not sitting at the ringside. They see it what boxing goes on. With their vast experience, I'm sure the government can, chisel out an act which will save us from all the future pitfalls, because we are already anticipating those pitfalls. People are already putting the red flag that please watch out, don't do this. Okay, if you do this, ultimately it's not the consumer, ultimately it's the economy of the nation that suffers. And I agree with Mr. Venkatesh that at times it might appear prima facie that the consumer is not benefiting, but the economy is. So it depends on whether you look at a short-term goal or whether you're looking at a long-term goal. My hunch is that the government, since it's already talking about this policy being carried till year 2047, my hunch is that the government has a very long perspective on it, and we should trust what the perspective that the government is trying to implement.
Point well taken, but Justice Chauhan, I disagree. I see these two people, as boxers who are chosen to go and punch and fight.
Please remember, the best of the boxers then become coaches.
if they don't get Alzheimer's before that.
So I think there'll be a few more episodes on this, because I'm sure that there'll be fine-tuning to this draft. Though it's being discussed in Parliament, of course, what happens in the committees, there is a lot of boxing, in fact, even goes on in the committees, I am told. Much of it's not out in the media, so we have no idea what goes on. But of course, information flow will come. We will just move to a round of closing comments for part one very quickly. Senior Advocate Badi Ranganathan.
So in terms of closing comments on this aspect, Tarun, I would say that before we try and put this plan into action, we should also try and work out on the nitty-gritties. We shouldn't try and put a plan into action and then start thinking about how to solve for the nitty-gritties. Let's do it properly as a package deal. Let's work out the nitty-gritties and then put this plan into action, is how I would like to see it.
Point very well taken. Advocate Sri Venkatesh.
Tarun, my closing comment would be that I think the government is there are two things. One is electricity is actually a concurrent subject. So a lot of this, what is being done, needs to be agreed by the states for it actually to be implemented. Therefore, I think they will have to play a conciliative role in terms of getting the states on board to agree to these radical changes in terms of tariff revisions, etc., etc. And discom more to do with tariff revision and the utilization of discom network, because there seems to be a lot of opposition in certain states on this aspect. So that I hope that is done on time. Secondly, I think the government is now realizing very clearly that our value of our sector, our power chain is with the distribution company, and if that value is getting locked because of political pressures, because of non-cost effective tariff being fixed, because of regulatory asset. I mean, regulatory asset judgment. Let's take us 30 seconds to dwell upon this. This judgment where Mr. Ranganathan was appearing and I was appearing for another party, which was delivered last year, is a landmark judgment on how regulatory commissions have sat on tariff revision year after year, only on the pretext of keeping, the larger forces happy. And that is a complete, it's a complete sad depiction of sad state of affairs in India, despite regulatory commissions being created. So therefore, the government realizes this problem. Now, this problem is now sought to be addressed through either policy initiatives or amendments to the Electricity Act. So therefore, I think it's a step in the right direction, but one must I mean, we as individuals have to also get alive to the fact that the cost of supply is going to go up, because internationally it has gone up. It is not that, we are sitting in an isolated scenario. Therefore, these are few things that one has to keep. The society at large has to come up to speed with this aspect, and then only this sector will flourish. So I think these are my closing comments. I think government realizes that we need to sort of unlock the value of the distribution sector as early as possible. And I think they need to anyways consult the state governments, because ultimately, constitutionally, it's still in the concurrent list. So therefore, they will not have an act which would, which will centralize a lot of things without their consent. So I think these are two things they must keep in mind, in times to come.
Point well taken. I'll go to Justice R.S. Chauhan for his comment.
While we are looking at the present, I think we should also think about the future. And that is what the policy is all about. It opens up a new chapter. And now that India is committed to cutting the emission by 45% from the level of 2005 by the year 2030, which is just around the corner, our next international commitment is that we will go for net zero emission by 2070. Therefore, there's a need to encourage renewable sources of energy. Plus, how do you bring that into your entire electricity sector? How do we grow? How do we do the storage? How do we do the firming up? What will be the rules and regulations regulating that sector? I think that will be what will be exciting. And to Mr. Ranganathan's and Mr. Venkatesh's future, I can assure them you'll get enough disputes from that sector also to keep all of us busy. But to me, that is the exciting part, because those are what the international community is now talking about. I mean, what was surprising in the last meeting in Dubai, a oil-rich company where the entire international community commits itself to committing emission and saying that we are no longer going to rely on, fossil fuels. Okay. To me, that is the exciting future that awaits all of us. And that is what we should all look forward to.
Point very well taken. But the last word has not been said on this issue yet. I think a lot of feedback from the states, and of course, I think the all crucial parliamentary committee, what inputs are given will also be very important. We'll take that on the next discussion, but I'd like to thank Justice R.S. Chauhan, Advocate Sri Venkatesh, Senior Advocate Buddy Ranganathan for coming in on this one and sharing their insights and speak as this policy is evolving. The final word on this will be out in a few months, if at all. These things do take time sometimes, but much more to be discussed. But this multiple players in one geographical area is something that is a touchy subject. Of course, Mr. Ranganathan highlighted that this has been done. Of course, there is railways that crosses through all geographies and is a separate supplier, but that's a different issue to be discussed Appreciate your joining us. Thank you so very much.
Thank you.
Thank you very much, Tarun. Thank you,
Thank
Mr.
you.
Chauhan. Thank you, Venki. Thank you.
Thank you.
Thank you.